So fundamentally, it's a claims-made policy. So this means that it covers claims made during the policy period. That's the trigger of cover. It's not an occurrence policy, for example, which would be a contrast. It doesn't relate to when the underlying event occurred, except in a couple of exceptional situations. It just applies to a claim that's made within the policy period. And who does it cover? Well, it covers individuals, that's the side A cover, directors and officers, but not just directors and officers, and I'll come on to that in a minute. It then covers under side B, the company where it indemnifies the individuals. And then side C, which I've explained, is the company cover for securities claims. Now, the key definitions, and I talked about this earlier, the key definitions are really these. I've listed them out here. And if you look at all of these definitions, it will give you a very good idea of the scope of coverage of your policy, okay? So insured person is a widely used term, and it covers a wider class of people than just directors and officers. It covers directors and officers, but it also covers senior employees who have a managerial responsibility. It will cover probably some named individuals or titles like chief information officer, that sort of thing. So people who have very senior roles within the company are likely to also be covered. The term director and officer is not normally defined because it's a legal concept. Statutes tend to define what a director and officer is. Statutes don't make it very clear either. It just says someone who acts as a director or an officer. So case law has generally scoped what those things are. And it's important to remember that someone who is a director or an officer is covered. And it doesn't matter what their employment status is. So I used to get asked a lot, you know, this person is a director and officer, but they're not an employee. They're just a consultant or a contractor. Does that affect my cover? Answer, no. As long as they're a director and officer, as long as the law regards them as a director and officer, they are covered. It doesn't matter what their employment status is. And it doesn't matter whether they're registered as a director or not. It covers them if they are in fact directors, okay? So it's quite broad, and it's there to capture anyone who is a director or is alleged to be a director. So obviously, they're going to have a claim against them in order to want to need the cover. So a claim is also broadly defined. It will include any written demand which alleges a wrongful act on the part of the directors and officers. So that could be a letter, it could be an email, but it also includes all types of proceeding. It includes civil proceedings. It includes criminal proceedings. It includes administrative or regulatory proceedings. So it covers, you know, really any type of threat that is made against the directors for a wrongful act. It has to contain a wrongful act. Now, what is a wrongful act? A wrongful act is just an allegation that they've done something wrong, really. If you look at the definition of wrongful act, it's very broad, and essentially it covers any act, error, omission, breach of duty, misstatement, etc. And or anything that they've done or not done in their capacity as a director. So it's very broad. But for a claim, you have to have that allegation. It have to be an allegation that they've done something wrong. Now that's different from an investigation, because an investigation doesn't require a wrongful act. So an investigation is usually an investigation of a person where they're the target. The director and officer is a target of an investigation, but before any allegation of a wrongful act is made against them. So that's the main difference. And of course, a regulator may call something an investigation, but it is in fact a claim, because the regulator may have already asserted that they've done something wrong. Not normally. Normally, when they're commencing an investigation, they won't make an allegation because they want to get the facts. But at some stage in the investigation, there will be an allegation made, and at that point, it becomes a claim. Okay. Does that really matter? Probably not, because actually there is really no difference to the cover between investigation and claims. It doesn't really matter, but an investigation can often become a claim. And indeed, an investigation may be a later stage of a pre-investigation. And as a pre-investigation is an earlier stage cover, which I'll come on to because it's provided by an extension. So obviously, they don't need the policy unless there's a loss as a result of one of these claims. And the loss includes defense costs, obviously, and it includes damages awarded, judgments, settlements, and really any loss that they incur as a result of this claim. It may include fines. The coverage may include civil fines. It won't include criminal fines for reasons I'll come on to, but it may include civil fines. So it includes a lot of things that the director and officer may incur as a result of this claim. Now, just pausing there, I've put in relation to claim, including securities claims. So securities claim is a subset of claim, and is only there really to deal with the side C cover. And because it's extending cover to the company for its own loss, it's quite carefully restricted to claims that essentially are securities related. They have to relate to a breach of the securities laws. They have to be brought by a security holder in the company. They don't include regulatory claims unless a director is a co-defendant. So the cover is quite restricted for side C for companies along those sort of lines, okay? But a director is covered for all claims, whether they're securities claims or other claims, okay? Now you have in the corner there a nice and happy looking board who've just realized they've got great cover, okay? So that's, they're looking happy. Haven't seen any claims yet, but they've got a great policy, so hopefully they won't have to use it.